5-judge bench headed by Chief Justice of India, D.Y. Chandrachud, has ruled against legalizing same-sex marriage. Justice Bhat, in fact, stated, and I quote, "This court has recognized that marriage is a social institution. Marriage as an institution precedes the state. This implies that marriage structure exists regardless of the states. The terms of marriage are independent of the state and its resources and sources are external." Now, while petitioners continue to urge that non-recognition of same-sex marriage amounts to discrimination against the LGBTQ community, the question that arises is marriage a fundamental right? We'll talk about this with our guest. Joining us on the show is Shrishti Mane, NGUVU Change Leader. She's joining us on the show. Advocate Ashwini Dubey, Senior Supreme Court lawyer and constitutional expert, also with us on the show. Advocate Desh Ratan Nigam, Senior Advocate and Political Analyst, also with us on the program. Savio Rodriguez, Founder and Chief Editor of Goa Chronicles, BJP leader, with us on the show as well. And Rohin Bhatt, Senior Advocate, Queer Rights Activist, also joins us on the broadcast. Shrishti Mane, I'll begin with you if you can hear me. Shrishti?
Hi. Yes.
Thank you for joining us. First up, what do you make of what happened in the Supreme Court today? There was division of perception. There was a division in terms of what the members thought of what should be done. What did you make of it?
Basically, it has granted legal recognition to same-sex marriages. It has refused, basically. And I'm sorry, can you just give me a minute?
Well, it hasn't given legality to same-sex marriages.
Yes, it hasn't been given. They did talk about, however, trans people being able to marry cisgendered people. However, there are multiple loopholes into that as well, and there has been no description of non-binary people or non-gender conforming people whatsoever in the ruling. And today's the entire ruling basically talked about the existing laws or the existing policies in rulings that are already there, and they were just, I feel, sugar-coated, a little bouquet, and told us with multiple loopholes. So I am really disappointed today. We've got a foot in the door. That is the situation that is happening right now. So the last time also,
you think you've got the foot in the door and the foot is stuck now, because after decriminalization there's not been much of an improvement when it comes to the rights that are given to the LGBTQ community.
Of course it hasn't. And talking about Special Marriage Rights Act, the way it is structured, in a way we knew that the way it has been structured, it is for heterosexual or cisgender heterosexual people, and that it was a little difficult how they would navigate around it. But we thought there would be, and the last time they had mentioned that they would set up a committee headed by the cabinet secretary to address the issue. However, that did not proceed as it was told to us. And similar thing happened today, wherein they told a committee would be set up, but there isn't any response that we're really getting.
Let me also rope in Advocate Ashwini Dubey into this. Ashwini, in fact, the Supreme Court said that they cannot change the Marriage Act itself. It is sacrosanct in its nature. They cannot uproot a system which has been going on and fix it on the basis of this petition. What did you make of it? And do you think that this is perhaps a big roadblock when it comes to equal rights and opportunities for the gay community in our country?
Vineet bhai, the judgment is significant in two parts, because the rights which were given in Navtej Kevar's case, that has been enhanced, and the CJI very openly and very candidly has asked the state government and central government by saying that, look, whenever any complaint is received by or against them, they should be treated equally. This is one. Second, all the judges have unanimously agreed the submission of the central government made on behalf of central government made by Solicitor General Tushar Mehta, that high power committee headed by the cabinet secretary will look into it and will submit its report, because The institution of marriage and the family are important social institutions in India that provides for the security, support and companionship of members of the society and bear an important role in the rearing of children and their mental and psychological upbringing. Now, third is, so far as the 160 odd more laws has to be changed, because if Vinit bhai, I and you had discussed this issue, the argument was going on, they should be given right under the Special Marriage Act. But Special Marriage Act also deals with the biological men and biological women. Very notion of that act says that it is between the biological men and biological women. It's one. And the second, that also talks about the prohibited degree of relationship. So how they will deal with the prohibited degree of relationship. Third, who would be male, who would be female. And fourth and important point is, all the judges have agreed that the right to marry is not a fundamental right, but it's a statutory right. And the moment it's become a statutory right, then the center or the state makes law within their legislative domain. And that is what, if we segregate the judgment in its ratio of 3 and 2, Honorable CJI, Honorable Justice Call, they said the right to union, right to marriage of a queer couple by the court was not possible. It is a legislative exercise. But at the same time, Justice Call says non-heterosexual and heterosexual unions must be seen as both sides of same coin. But Justice Bhat and the Justice Narasimha and Justice Call, they said there is no fundamental right to marry guaranteed by the Constitution, though queer couples have a right to live together unhindered and undisturbed. Now, Vinit bhai, one more important facet of the law. Law says there are other laws, like who deals with the divorce, Indian Succession Act, Inheritance Act, Adoption Act, property rights. So ultimately that talks about male and female. So who would be male? Suppose it is a gay marriage between two gays, who would be female? If it is between two lesbian couples, who would be male, who would be female? So court said that, look, it is within the legislative domain of the parliament to make law by referring various judgments, by referring various practices, societal values and other laws which is prevalent in the country. And now, another thing, the Navtej Kehar's case, the same Supreme Court granted same-sex couples the freedom to lead a dignified private life. So that, and 377 was decriminalized, and here certain more powers have been given, rights have been given under this law, that yes, they can live in a dignified manner. But so far as they're granting them a status has been advised, is not possible. It is not within the intent within the powers and domain of the Supreme Court, because it is the right and prerogative of the parliament. And even in other countries, more than 30 countries have given recognition. You say the law has been evolved through the parliament only. The courts have only looked into it, but here neither they have the fundamental right, neither. And moment it comes to the statutory right, then it remains with the domain of the parliament. And that is what the Supreme Court very significantly, considering various aspects, considering that a marriage between a biological man and biological woman takes place either under the personal laws or codified laws like Hindu Marriage Act, Christian Marriage Act, Parsi Marriage Act, Divorce Act, Special Marriage Act, and Foreign Marriage Act. The parties entering into marriage creates an institution having its own public significance, and it is a social institution from which several rights and liabilities flows. So that's I think this judgment is also given certain rights, and let's see what happens tomorrow when the cabinet secretary submits its report to the parliament. Maybe parliament makes wisdom, may give certain more rights to them. Over to you.
All right, let's see what the parliament does. But Mr. Nigam, what do you think? Marriage, is it a fundamental right?
Oh, well, the Supreme Court, Vinit says it's not a fundamental right. It's a statutory right flowing from the customs. And obviously, it was a customary right, and then it became a statute, became a part of statute, especially under the Hindu Marriage Act and Christian Marriage Act, and we don't have any Muslim Marriage Act like in the sense of codified. So we don't have that uniformity. Now, I am quite intrigued with this judgment. Intriguing in the sense they have clearly said there is no legality to the same-sex marriage. On the other hand, they say they can marry under other acts and other laws, including personal laws. All those laws prohibit same-sex marriage. Unless the changes are made by the parliament under those acts, the real confusion, the problems will arise, because queer couples will go forward and marry, that will not be registered, and where the Supreme Court says they can marry under the personal laws and other laws. That's inherently contradictory thing, some kind of an appeasement, being done here. On one hand, you say no legality to same-sex marriage, and on the other hand, then you can marry under other acts and personal laws. When those very same acts prohibit that kind of relationship and a marriage, it does not give legal sanction to it. That is inherently contradictory, and this will lead to a lot of confusion in the future. That probably required some more thinking on the part of the judges in the Supreme Court. And the various other aspects has been covered by Ashwini ji. The fact remains that they have only dealt with transgender. They have left out LGBTQ and plus. Plus has never been defined. The Tushar Mehta ji said there are 72 shades. And another very disturbing fact is, which is tearing up apart the women's rights in US and the American society, is that gender is not the same as sexuality. There was recently a cycling competition in US where first two positions went to the males.
Transgenders.
Yes, they were actually, it's not very clear they're transgenders or male. They said they took part in the women's racing cycle. Please remember that. And they got two positions out there. And this is going to infringe on women's rights. So all this, halla bulla and everything is going to harm women a lot. Remember that. There are DV Act, the domestic violence. How do you deal with that? There are other alumni and maintenance issues. How will you deal with that? It is all going to impinge the women's rights out here. Unless until you go deeply into all that, it will be very difficult. The kind of society we have, it's a social institution, as everybody agrees, arising out of customs through thousands of years, where biological man and biological women have been, clearly distinguished. And now if you give a choice to a person to decide about own sex, irrespective of whether you are a biological man or woman, is a sure recipe of disaster and anarchy in our society.
All right. Savio, what do you make of what happened today? Obviously, the queer community is very upset. They feel that, just to decriminalize, what they were all about has taken them so long. This, in fact, is another long, hard struggle. And this is not about, asking for something which is not natural. They say their condition is natural, it's an act of nature. Then why deny them, this fundamental right, or this right for that matter?
No, we need the concerns of the LGBTQ community and plus is a very, very genuine and a very strong concern that we as humans need to understand and try and bring it into some sort of legality to protect their rights. The Supreme Court is absolutely right when it says that it is not a fundamental right for marriage. Marriage is not a fundamental right, it's a statutory right. And therefore, when you look at it from, say, a religious perspective, for example, which religion, whether it's Islam, whether it's Hinduism, whether it's Christianity, which religion allows for same-sex marriages to happen? It does not. Right? So therefore you go to the court, you go to the civil court, and you hope that the civil court will provide rationality for this kind of a relationship. The real problem is people understanding the kind of relationship. It's what I think we get wrong. People are not able to understand that this is not about a physicality. When two people come together and love each other, irrespective of their sexes, it is the love that dominates it. The physicality of that relationship is secondary. So when somebody wants to get into a marriage act with somebody, there's a lot of emotion involved in it. There's a lot of the mind involved in it. And there might be some aspects of the physicality. And therefore, it is important for us to be able to bring this into some sort of understanding of the concerns of the community. And they need to have their rights protected. So by decriminalizing homosexuality and various other things, you have only taken the first step. But beyond that, how do they stay together in a relationship which is very similar to a biological man and a biological woman? Let's say, for example, two men want to be together. They want to be in a relationship. Why is it necessary for us to define whether they are a husband or a wife? What is important is that they are in a relationship, and within that social institution, the parliament, as the Supreme Court rightly says, has to decide on the laws that are applicable to people who want to get married of the same sex. And that's where the complexity lies. The complexity lies in us trying to understand the emotional and the mental concern around the relationship. It is easy for us to say that it's normal for a biological man and a biological woman to be in a relationship because that's how nature wants it. But I don't think nature is being unfair to the people who are of the same sex as well. It is us as society who's being unfair. If two people fall in love with each other and belong to the same sex and want to live together, there should be a legality allowed for them in order to take that forward. Religion does not allow it. Many of the religions don't allow it. But if you actually look back into a little bit of Sanatan Dharma, where there were transgenders who were accepted in society, the Sanatan Dharma beliefs allowed for transgenders to be accepted and to be considered not to be a violation of nature. That's the problem. The problem is in how we look at the entire issue. The issue is not physicality. Physicality is a secondary aspect of it. A lot of people are in an emotional attachment with people of the same sex. Even for that matter, a person who feels he's a man while being a woman wants to become a man because that's an emotional attachment. You might want to say that it falls in the purview of like people have described it to be a mental concern. I don't think it's that. I think people need to give it an emotional understanding, and around that frame the laws that are necessary to protect these rights, just like you would do for a biological man and a biological woman. That's important. You need to understand that they are humans. They do have fundamental rights, and as fundamental rights that they have, they must also have their statutory rights if they want to get into a relationship with each other.
All right, Rohin Bhatt. Well, the court said what it did, but you find yourself on both sides of the fence, right? How do you rate what happened today, and is this in fact indicative of a continued struggle by the queer community that has lasted and persisted for so long?
Right. So I'm going to deal with this question in two parts. The first part, I want to talk about the Supreme Court judgment, and the second part is what your other panelists talked about. Let's talk about the Supreme Court verdict first. I think it's an extremely disappointing verdict from the Supreme Court. This is nothing but an abdication of this by the Supreme Court of the duties that it is bound to protect. It has in the past, in Shafin Jahan, in Lata Singh, recognized that there is a fundamental right to marry. However, today the court turns those rulings on their head and says that it is not a fundamental right to marry. Be that as it may, the judgment today has reaffirmed what a lot of us who are queer lawyers always thought, that no matter what the judicial platitudes say in Navtej, in Nalsa, these judgments run into hundreds of pages, as I fear today's judgment would too. And at the end, it gives us nothing in terms of rights that actually accrue and precipitate for queer people. So it is a disappointing day as a queer rights activist. It's a disappointing day as a lawyer. It's a disappointing day as somebody who believes that the Constitution is my first love. Today, I feel let down by our courts. I feel let down by our Constitution. Now, let's go one by one to the arguments that the other panelists made. Now, somebody said that, marriage is only between a biological man and biological woman. Let's be very clear. The Special Marriage Act, the Hindu Marriage Act, or any other marriage law does not use the word biological. They say the word man, they say the word woman, they say husband, wife, or spouse. We were asking for an expansive reading in line with jurisprudential principles which are laid down by the Supreme Court itself. Now, somebody else talked about societal value of marriage. Let's talk about it. We say that the court should not interfere in issues of marriage. Yet, day in and day out, we find our courts interfering in marriage. Few months ago, the Supreme Court gave itself the power to dissolve marriage on the grounds of irretrievable breakdown of marriage. Was that not interference with marriage? Why was there no opposition there? Even a few years ago, when Joseph Shine decriminalized adultery, why was there no opposition there? The problem here is that queer people who've been systematically disenfranchised in this country, when we assert our rights, people have a problem. Somebody else talked about religious laws. The Pope a few days ago came out in support of same-sex couples and said he would have no problems if Catholic priests blessed same-sex couples and their marriages. And let me deal with the final argument, and which is quite important, is that of trans rights. In 2014, in the Nalsa judgment, the Supreme Court held that the word sex in Article 15 should be meant to read as gender, sex, and sexual orientation. This finds reiteration in today's opinion of Justice Chandrachud. It is for nobody, including the state, to tell people what they identify as. My gender, my sexual orientation is nobody's business, including the state's. 9-judge bench of the Supreme Court in Puttaswamy has recognized it, and anybody who wishes to disagree is feel free to get any legal recourse that they may want to. Be that as it may. A cycling competition was brought up earlier this year. Now let's go back. The case, if I'm not wrong, was that of Austin Phillips. She rode to victory in the 5th stage of the Tour of Gila, right? One of the few remaining marquee stages races in the United States. She won the race by 21 seconds. There was backlash to this, as was expected. The World Cycling Body said she did not breach any laws or any regulations which they put down. Now, who are we to decide for somebody else? Understand this. Your problem of domestic violence, of alimony, of maintenance stem from patriarchy. They stem from these biological men raging havoc on their wives. It is not queer people who are doing it. It is cis men in heterosexual marriages emboldened by patriarchy who have led to these protective statutes.
Are you saying that there is no violence between queer partners?
Absolutely not. I'm not saying that. I'm not saying that. Of course, there's intimate partner violence. Nobody is denying that. What I am contesting is that this intimate partner violence in cisgender heterosexual couples is mostly perpetuated by cis men. So let us not use those facetious arguments and legal whataboutery to deny queer people equal rights.
All right. Okay, Mr. Nigam, we've run out of time, but you want to respond to that? Mr. Nigam?
The fact remains that nobody is denying that they don't have a right to marry, but that legality is in question. Please understand that. You can choose your partner, you can live, but the state and the parliament have their own duties to perform.
Yes, they do, and that duty is to uphold the constitutional right of equality.
Yes,
and in that,
please hold
in
on,
the
please hold
times
on.
that we live in,
Allow me. It's my time.
disenfranchisement of queer people. Let us not forget that.
It's
Right,
my time.
Rohin, let him finish. We've run out of time. Let him finish.
See, the fact is, again, nobody, even in ancient times, nobody said that they cannot marry. But that was not given social recognition. That's the difference. You can continue in a relationship. That social recognition only society can decide. In a democracy which is run on rule of law, the parliament decides, and that is where the Supreme Court has drawn the line. It says, let the parliament decide. It is there in the best position. Otherwise, what will happen? We'll have a same kind of judgment as we had in Jallikattu, not obeyed. Sabrimala, not obeyed. You give a judgment ahead of its time, or when the parliament or the people of this country do not want it, the elected representatives have not brought up this issue. There is no sufficient pressure on them. Therefore, the parliament has not taken up this issue. Maybe tomorrow, maybe after 10 years or something, they may take up the issue. We don't know.
Yeah, and the Honorable Court also said that, the same bundle of rights which every married couple has and has enjoyed should be available to same-sex couples as well. So that is a silver lining. Rohin, we have unfortunately run out of time. Would like to thank everyone for being a part of this conversation.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.